For the People Theaters v. City of New York, Tens Cabaret v. City of New York.
Good afternoon, Your Honors.
Good afternoon.
May it please the Court, my name is Ingrid Gustafson, appearing on behalf of the city. I would like to reserve 3 minutes for rebuttal, please.
You have it, thank you.
Thank you. In addressing the very narrow question presented by this Court in 2005, both of the lower courts applied the wrong legal framework. This Court was clear when it remanded in 2005 that it was not remanding for the typical trial where the courts below could make a judgment based on the preponderance of the evidence, but instead was remanding for a special proceeding to test whether the city could come forward with evidence renewing support for its legislative judgment on predominant sexual focus.
And where does intermediate scrutiny fit into that analysis?
As this Court recognized in 2005, intermediate scrutiny requires additional scrutiny. However, it does not mean that deferential concepts go out the window. And what it requires, in the words of this Court, is more confidence between the means and of the city's regulation and the ends that it's trying to serve. And it was very clear about what the city needed to do. It needed to come forward with evidence fairly supporting its original legislative judgment.
So I guess my bottom line question is, did that standard have any role in this proceeding according to our 05 decision?
Absolutely. This Court, when at the end of its decision, when it was laying out the precise standard, used the fairly supported language. And that makes sense, because that is the ultimate question always in this proceeding. Whether it's step 1 or step 3, it doesn't change. It's always the same question. Has the city fairly supported its legislative judgment? And this Court stated, if the
Is that a standard of proof? Is that something is that a recognized standard of proof that we've ever used in any case?
It's very specific to this area of the law, Your Honor. Yes,
Fairly supports is
fairly supports comes from Alameda Books, which this Court said in 2005 governs the scope of this proceeding.
But wasn't Alameda in the context, and wasn't the earlier decision in the context of a summary judgment proceeding? Didn't that have to do with shifting burdens in order to get to this hearing?
Respectfully, no, Your Honor. And this Court clarified when it was remanded, it used that exact same language, because the ultimate amount of evidence, is the same. It's still very little evidence. This is a very particular area of the law, Your Honor, and the courts have
Yeah,
gone
but
into
in 2005, the court did make clear, although you're right about the very little evidence, that the evidence was targeted, or the court anticipated the evidence would be targeted.
Yes.
And the court said there's a triable question of fact as to whether the 60/40 businesses are so transformed in character that they no longer resemble the kinds of adult uses found both in the 1994 DCP study and in studies and court decisions around the country to create negative secondary effects. In addressing this factual dispute, we anticipate that the city will produce evidence relating to the purportedly sham character of self-identified 60/40 book and video stores, theaters, and eating and drinking establishments or other commercial establishments located in the city. And then goes on to say what you don't have to put forward. But it is clarifying there that the court anticipated, as it says, that the evidence was going to be focused on a particular type of factual dispute.
The central question, yes, was predominant sexual focus, and that is what all the evidence is going to. Now, there are facts, of course, in these proceedings. The background facts about the nature of the establishments ended up essentially being undisputed. And yes, this Court did use the term factual dispute and question of fact. But I would submit that's not surprising. When we were talking about, those are the normal terms you use when talking about summary judgment. But we have to remember whose factual findings we're disputing here. We're disputing the factual findings or the findings of a democratically elected body, the legislature's judgment on predominant sexual focus. And this court went on to clarify that this was not a preponderance of the evidence, a standard where a new judgment could be made by the trial courts. Instead,
But I see this a little bit differently, perhaps. It seems to me we all know the long history of these cases. When it came up here the last time on the new changes that had been made, this court said, you don't have to go back and prove the secondary effects I think what we were trying to get at, what the unconstitutional thing would be that the city would be doing is say, we had the 60-40 rule, but now we're going to make this rule if you have one pornographic book in your store, it's still predominantly, pornographic, sexually oriented, whatever the term is, and clearly that would be content-based because that cannot have the same secondary effects. So it seems like we were sending this back to say, do these entities still resemble or still have the same kind of primary focus that the entities were, that you were allowed to legislate in this way against and zone and do whatever you were going to do. So it seems to me that was what we wanted to be determined in this hearing.
Well, there are 2 points, Your Honor. First, I'd read it differently. I mean, I don't believe that the court opined that just even one peep booth wouldn't be enough. It was remanding for a closer look, concrete evidence on the nature of these establishments, and that is exactly what the city
I didn't think they were doing
adduced.
that. I thought the court was sending it back for 05, in the 05 to meet the third prong of the Alameda test. That's the way I read that decision.
That's correct. Renewing support for the legislative judgment.
Right.
It wanted.
Directly focused on, so let me just stop you a second. Let's assume that's true for a second in argument. If that's what it was remanded for, then the court had already made its constitutional determination as to the application of intermediate scrutiny, and that's the standard of review that we're not dealing with today. Do you agree with that?
The same Constitution, here's what I would say to that, Your Honor. First, yes, the court determined what framework applied and what the constitutional standard was.
The
But
law of this case is that constitutionally, then intermediate scrutiny has been applied, and now the question is, it's not a standard of review question, but rather a burden of proof question. Did the city meet that burden of proof as to the third prong of the Alameda test on remittal?
That is the question, Your Honor, but this court did not uphold the constitutionality of the amendments in 2005. If it had, then the courts would not have, lower courts would not have been able to strike them down on remand. The ultimate question is still constitutional, and yes, it is a burden of proof question, but it is always tied into what is the city's burden under the First Amendment, under the New York State Constitution. What evidence must it have to satisfy intermediate scrutiny? That is always the ultimate question. And the evidence the city adduced here was very different than what was in the original legislative record. The city adduced extensive evidence about 10 different bars and clubs and 14...
It was about the evidence about the internal, right, the internal
Yes,
materials, the setup.
All-
That's what you say is different?
No, the detail. The original legislative record was anecdotal. It had examples. It had reports. It had conclusions by city officials, but it didn't have this level of evidence. And what this evidence showed, and the first
I'm
department.
saying that first report, did they actually go into the clubs that they went into for purposes of this remand? Had they gone physically into those clubs?
They went in. I think I might be misunderstanding your question. And post remand, did the city go into the clubs?
Yeah.
Is that the question?
Yes, well, I know you did, because that's your evidence. My
Ab-
question is originally, for the first report, or the 1994 report, whatever it was, had they gone into these clubs?
That has been a matter of some dispute. I mean, in the sense that was there
that a no?
a clear? Well, they knew what was going. They knew they were topless dancing
that a
clubs.
no? But is that a no?
Stores. I don't precisely know. I mean, what exactly was done then, but they knew what was going on inside of the establishment. So the idea they literally never entered them. I mean, was there a clear analysis of the nature of the inside, in the way that we have now on this record? No. But what we have now is ample evidence of predominant sexual focus. And the First Department actually held that there was evidence in the record supporting predominant sexual focus. It then went on, though, to find that outweighed, which
But I
was the.
need to- This is a complicated area of the law, you're right, and I need to be clear on what your position is. Are you saying that the question is not the standard of view that the city applied to the city showing that zoning was justified by a government interest in regulating this particular activity? You're saying that the 2005 case, the way I read it, seems to say that's intermediate scrutiny and that's the law of the case. That's what applies here.
Yes.
So then, the second question is, it's not a standard of review question. It's not, under your argument, not an intermediate scrutiny question, but rather, what's the burden of proof for the city, and have they met that burden of proof? So if
They
it's-
are-
what does fairly supports mean, in other words?
They're intertwined because we're still, I think there's unfortunately no way to get out of the fact that we're under the same intermediate scrutiny framework. We're just at step 3 of that framework. But yes,
Okay.
it is the courts below, it is a legal framework question, though, and a standard of review question, though, because both of the lower courts did apply the wrong one and stripped all deference from the analysis. Again, the First Department said in its opinion, with respect to both the bars and clubs and the book and video stores, there is evidence supporting a legislative judgment on predominant sexual focus, but then went on to find it outweighed. If I may return.
So is that their mistake? Your light has gone off, so if you could answer this on reply. Is that their mistake that they went that extra step and did some other kind of factual finding, imposed a burden that the Court of Appeals did not impose in 2005?
If I may briefly.
Well, that's a yes or no, but you can
Yes, yes,
go
that's the
further on
prime-
reply.
that's the primary
Okay,
mistake.
come back to
Sometimes
it,
there
come
are
back to it
others.
on your rebuttal. Thank you.
Good afternoon, Your Honor. Erica Dubno from Farringer and Dubno for the respondent bookstores. At the outset, this case shouldn't be here anyway. This is, as a matter of fact, a factual dispute. It was remanded for a factual determination.
But the result of the factual determination is either that the regulations are constitutional or they're not constitutional, right?
That's correct, Your Honor, but
So
the
this is
actual.
a constitutional question that's up before the court now.
You can't manufacture a constitutional question by saying a fact will turn it, the determination will turn on that. The reality is the Court of Appeals in 2005 already determined that everything had been determined that needed to be done, except for, as Judge Garcia pointed out, are the establishments, the 60/40 establishments that exist today, substantially similar to the ones that were studied back in '94.
We can't tell you whether the statute is constitutional or not constitutional until that last issue is resolved, right?
I beg to differ, and I think that it's
Isn't
not,
the claim a
but
constitutional claim?
there's no
Like, I
question
mean,
that there's
we not
not.
hear about the First Amendment?
We're certainly here about the First
Is that part
Amendment,
of
which
the
is why I think, but at this point, it's important to note that we're dealing with a burden of proof here, and that we had a trial judge who went to the establishments, he visited them, I was there, he personally inspected them. We had a judge who heard witness testimony.
Constitutional questions can never turn on issues of fact?
I think that this court doesn't have fact-finding power, and certainly they're trying to transform this into a constitutional issue when the real issue on
Well,
remand
we do
was-
have, but we do have at the very least, the power to determine whether the correct standard of review and burden of proof and application of, whatever the analysis is. One of the things that everybody seems to disagree about are these 4 factors that the court referred to and how you take them into account. At the very least, aren't those issues that are appropriate for us to look at?
This case came up as an appeal as of right, not a leave application. The basis was that it was either a constitutional question or it was a dissent by 2 justices on an issue of law. If you look at the actual dissent, it wasn't on an issue of law.
Okay.
They reviewed the
But-
facts.
So let's say we disagree with you. Now let's get to the merits of it.
Absolutely. Getting to the merits, Your Honor. Certainly, the burden of proof in this case was absolutely met. There was no concern about whether or not the 4 factors that the judge considered. The appellate division didn't dictate that these were the only factors that could be considered, but they gave some kind of guidance. We needed some kind of benchmark, because unfortunately, the remand from the court.
They had 4 factors, and the dissent basically said that the very little evidence standard referred to in Alameda was met. So we have a fairly supports language that's being used, and then we have a very little evidence standard that's being used. I'm having a hard time reconciling those two concepts for the same case and the same burden of proof. You see what my problem is?
Certainly, I welcome that, Your Honor. I mean, I think we all realize that we're here on a Stage 3 Alameda analysis, and that because the Constitution and First Amendment free expression is involved, we're dealing with heightened scrutiny there. Relating to the amount of evidence, the quantum of evidence that needed to be produced, we take the position that it should be a preponderance of the evidence that fairly presents, certainly is one aspect of it, but we're above rational basis at this point. Rational basis was step 1 of Alameda. We met that. In fact, now we're on Stage 3 here, and their burden was higher, and they simply didn't meet it. These were factual determinations that were made.
The phrases that we're stuck with here in the law of this case is fairly supports and very little evidence. Which phrase would you apply to the standard of the third prong of the Alameda test? Are you saying it's a very little evidence question that the city has to meet, or fairly supports, the evidence has to fairly support the proposition?
I don't totally understand the distinction between the two. I think there's an ambiguity there. I understand what
I
you're...
think there's an ambiguity there,
I-
too. And that's one of the difficulties I have with the case, because I'm saying to myself, well, how much do they have to show to meet their burden?
More than they did.
Well, that's, that's a good argument. But,
Is part of the tension amount versus quality, and aren't we left with quality as being what this boils down to? Is the evidence good enough at the end of the day?
Certainly, the evidence was disputed. It's not true at all what the city's maintaining, that it was undisputed all the time. We had a 5-day trial on this. There were witnesses that testified. They presented videos where they zoomed in on certain things, saying this was adult material, but they didn't videotape anything else in the store.
Let's stick with the burden, okay? Because the details of it, we get lost in those weeds, it's a waste of time. For now, if the standard is very little evidence, they win, don't they?
I still don't believe that they meet the very little evidence. Certainly, if
It's
there's
not much, very little isn't much. You know,
if there's a debate between the two, certainly fairly presents, which is what was in the remand, certainly would be above very little
So
evidence.
by analogy, let's say you're relying then on fairly supports, it is stronger for your case. What would you compare it to in New York jurisprudence as a standard of proof? You just made reference to preponderance of the evidence. Is that what you're saying they have to meet here?
Certainly, and there is authority that at the Stage 3 of Alameda, it's a preponderance of the evidence. The rational basis, which is Stage 1.
I saw one Seventh Circuit case. That was the only case I saw that actually said that.
That's correct, Your Honor. This is an entirely new beast for everybody. It's not something that's been litigated throughout the country, but the Alameda standard is higher. It's free speech. It's
Okay, but
heightened
why isn't it
scrutiny.
under Alameda and what we've said in 2005, that you could have a small amount of evidence, not a lot, but the quality is what resonates, and that it then fairly supports. I'm not sure I'm understanding the equation that you're arguing for here.
Well,
Just a little bit of evidence is never going to be enough, isn't it, about the quality of that evidence? And I don't know that you can say this is a little bit of evidence, but let's even assume you're right about the quantity. Is it still about the quality?
certainly, either if it's quality or quantity, in this situation, what was presented was insufficient, as found by the trial judge and the majority in the appellate division. They have fact-finding powers, and they all reviewed the evidence and found.
Narrowing it down then, we have the appellate division saying there are these four factors, and only one of those four factors supports the city's position. The city says that factor, even if you took that by itself, the boost would be enough. Is that really what we're deciding here? This court today, what you're asking us to decide, are we narrowing it down to that? The issue of whether or not the appellate division majority's application of equally weighing those four factors, signage, display, I think where the book's located, and the question of the booths, as opposed to the dissent, which was saying the booths alone will be enough to meet the very little evidence standard.
Yeah, certainly, I mean, we never advocated the four-prong test that was promulgated by the appellate division, but which we're stuck with now. But even to point that out, at this point, certainly the appellate division and the trial court weighed the issues. They made the determination. I don't think that there's anything unreasonable about it. The determination, those factors derived from the DCP report that was promulgated in 1994, which was the basis for the law in the first place. So it was a rational thing. Whether or not, having a few booths, they've already said having a booth wouldn't be sufficient. the question is, are you going to automatically say that an establishment that has 1 booth, 10 booths, 20 booths, whatever the number is, automatically constitutes an adult establishment? Then why was this whole 16-year purpose, they could have just put that in the law in the first place. It wasn't done, and the reason it wasn't done is because that doesn't constitute an adult establishment. No study was done.
Is there any establishment that the only proof is the booths? Any establishment in which it's only about booths?
I would say that of the stores that were selected by the city at the trial, 9 out of 10 of them did have booths.
No, I understand, but only booths, they had nothing else?
No,
Sounds like you're arguing if there's only a couple of booths, then they're not covered, and that's not the intent, and that's not what the 1994 report was referring to.
right. The stores have other aspects to them. They have a variety of merchandise there.
Thank you, your light is off.
Thank you very much, Your Honor.
Counsel.
Good afternoon, may it please the court. Edward S. Rudofsky for the Cabarets. Just to be clear, we had a separate trial, so it was not just a 5-day trial, it was 2 complete trials, very extensive. The fundamental flaws in the city's case were twofold. Number one, its failure to prove the degree of transformation between the establishments studied in 1994, the so-called 100% establishments, and the establishments sought to be regulated in 2001, the so-called 60/40 establishments. And separately, its failure to prove, quote, how speech would fare, close quote, under the 2001 amendments if they're permitted to take effect. And, Your Honor, I think the answer is the city never perceived that it had this burden, even after the appellate division ruled, and it introduced no evidence. The evidence the city introduced were the testimony by inspectors as to the interior of the clubs.
But I thought that's what this court said in 2005. Show us that it was a sham, that they really weren't transformed, and that the predominant focus of these facilities was not sexually
Yes, but
sexual.
in this field, if you go back to Renton and look at everything through the lens of the case law, it ultimately, although we're not challenging the 1998 ruling, it's ultimately about secondary effects. It's about signage, it's about crime, it's about property values. It's not about.
No, I think in 2005, this court made clear you're not revisiting the second offense.
Yes,
This is not what we're
agreed.
doing.
But the investigation, the testimony that the city adduced did not address any of the elements that were studied in 1994. Why is that significant? Because what was 2005 about? The city did not want to do another study and said, we want to rely to constitutionally justify the regulation in 2001. We want to rely on the 1994 study, which was not about the interior of the clubs. It was about secondary effects
Was there not testimony about the interior of the clubs?
in
No, at this trial on the
yes,
remand.
of course there was. That was-
Okay, so I'm
that
not
was-
sure I'm understanding your argument then.
It's an
If they've
apple-
not, in 2005, the
apple-
court, 2005, the court remanded so that they could indeed meet this third prong and said, we anticipate that they are going to present evidence.
But
And they
the-
did about the interior, did they not?
Yes, but the court in 2005 said, use the words "so transformed," which becomes pivotal. The Court of
Which is
Appeals
what the
has-
evidence has to show.
Show
but-
us how they were transformed or not transformed from 1994. The problem is, you're comparing 1994 exterior.
Well, you're saying there should be a new study, but I don't think that's the
No,
issue.
I'm not.
Well,
We're
what are
not
you saying
there
then?
should be, the
Yeah.
court, your predecessors clearly said there didn't have to be a new study.
Mm-hmm.
The city had a choice. It could either have a study or not, or it could come forward with evidence that would fairly support the proposition that the 60/40s were the functional equivalent for this regulatory purpose of the clubs that were studied in 1994.
And you're saying
So
they
you
they
have-
couldn't do
you have
that?
the 1994
You're saying they couldn't do that because there was no study in '94?
No, they could have done it, but they chose not to do it.
What is the evidence?
They didn't
What
do
is
it.
what
I'm
is the
saying
evidence you would have liked them to put in to meet their burden?
We put in evidence, and they could have put in evidence, we had a signage study done, we had a crime study done, we had a
But this
property
court said you
value-
don't have to do any
They
studies.
have to doesn't mean you can't, Judge. They had to come up with some methodology.
You
for-
seem to want to impose the exact burden we said they don't have.
We don't want to impose any burden. The government is seeking to regulate free expression. It's got to prove at the end of the day.
But counsel, I'm sorry, I think your argument here is we said they could rely on the old study, and then they had to show that these characteristics of these businesses still retained the characteristics of the businesses that the city sought to address in that in the original law. But I think your next part, which I'm having trouble following, is they had to use exactly the same criteria used outside versus inside of those businesses that were used in the 94 study, and I don't think that's what we said in 2005.
I agree that the court did not tell them what they had to do.
But we did
The court
tell
told
them.
them what they didn't.
We told them that they had to show that the predominant ongoing focus was on sexually explicit materials, and it didn't say inside the
And
bookstore, outside the bookstore.
I am merely suggesting to your honors that when you read the 2005 opinion, and you read the case law in this area, the question of what focus are we talking about? Where the whole area is concerned with the effect of the business on the community. It is not concerned with what goes on inside the
But
club.
what goes on inside certainly has an effect,
But that-
because it goes to traffic, it
And
goes to
that-
the presence of the business in the
I
neighborhood.
couldn't agree more, Judge. The record is barren. They never connected those dots.
No, but they connected, I think the disconnect we're having is they connected those dots originally. So all we said to take advantage of the connection you originally made is that you have to show this predominance remains.
Okay, and I'm suggesting.
That your compliance, in essence, was a sham, so we're back once again to the
I'm
burden.
suggesting that.
Let me finish. We're back once again to that burden of proof problem.
100%, Judge. And I'm suggesting that a close reading of this record and following the sequence of what went on, they didn't do that. They proved something else. But let me turn, if I may.
What
I'm
did
sorry,
they
what's the-
prove?
Yes, what's the something else they proved?
The something else is that the second part of the constitutional test, as we've addressed at some length in our brief, is how speech will fare. In 1995, 1998, the city represented to this court, with respect to the earlier version of the statute, the 1995 statute, that the 60/40 form of doing business, the substantial portion component of the definition, would increase and expand the availability of protected speech, and that therefore, and we've cited the chapter and verse in our brief, the 1995 rules were constitutional because the substantial portion test was written into the law, and that would permit the less intense use, the under 40% use, in a dispersal plan, which this was, a dispersal zone to disperse the concentrations of adult uses out into the boroughs, that they adopted a dispersal plan, and they said that less intense use would be available throughout the city, and that would satisfy the constitutional concerns. They then turned around in 2001, and they took 40% down to zero for the clubs, eliminating that expansion that they addressed in 1995, eliminating that factor. With respect to the bookstores, they severely restricted, without eliminating, severely
And
restricted.
so I'm sorry,
the
what is it you say that they proved on the remand?
They
I'm
didn't-
losing the
They
thread.
didn't address on the remand how speech would fare, which is part of the test that Justice Kennedy articulated in Alameda Books. The 2005 decision makes it very clear that Justice Kennedy's decision is the controlling decision.
Well, to the extent there's agreement with the plurality. Okay, Counsel, your light is off. Thank you so
Thank-
much.
There are three major points I'd like to hit. First, I will return, Judge Rivera, to the question that you asked me at the end of my opening. I want to go back to also talk about the burden a bit and how very little evidence fits in with fairly support. And then this issue of the interiors of the club and the Kennedy Center I will deal with at the end. Yes, Your Honor. What the majority got wrong was that it went too far. The majority found, and it wasn't just based on single peep booths, the majority found, based on the city's evidence, which showed that the clubs had between 7 and 60 peep booths, and very graphically showed they were promoting adult entertainment, showed that there was interior and exterior signage, large signage, promoting those booths, both inside and outside, showed that layouts, in many of the stores you had to walk
Ultimately,
through.
the question for the trial court and then the appellate division to determine is whether the city met its burden, whatever that burden was, of showing that these establishments maintained their predominant focus on sexually explicit activities, correct?
Yes.
Okay. So doesn't it boil down to what is that burden? And, right?
The burden, it's very little evidence, but the evidence nonetheless must be, it has to have a qualitative value, it has to be relative, it has to be relevant, it has to be credible, and it has to fairly
Slow down.
support.
Both your parties are placed in an impossible position because the court really here is confronted with two different phrases to characterize the burden, right? One says fairly supports, and the other one says very little evidence. And that's the territory we have to navigate.
My position, Your Honor, is that the fairly support is a further development of the very little evidence. It's explaining what type of evidence you have to have. I mean, it has to be evidence that's relevant, it has to be credible, it has to be of a sufficient quality that the court is satisfied that the city acted reasonably. So I believe there is a connection.
Isn't it true then that those courts found that it wasn't satisfied with that proof?
They applied the wrong legal framework, Your Honor. Both eliminated deference. They answered the wrong question. Supreme Court said that the deferential standards
Your
did
point
not.
that as a matter of law, you met the burden?
Yes.
Matter of law, and that whatever factors the AD applied, whether they're appropriate or not, is almost irrelevant.
Yes.
Because with those factors, without those factors, as a matter of law, you've met the burden.
That is exactly correct, Your Honor. Because the background facts about the nature of the establishment are not disputed, this court can decide this as a matter of law. It can do it in two ways. One, just taking the first step of the majority division's analysis, and two, based on the undisputed evidence in the record. And if I may turn to this issue of the interiority of the clubs very briefly. As this court said, the court was clear in 2005 the city did not have to come forward with additional evidence about secondary effects. Secondly, I think this is a bit of a red herring. I mean, the city has been functioning throughout these trials with some caveats under the assumption that the former establishments were 100%. That is, that they were entirely devoted to adult booker videos and materials or to topless dancing. And the task that was set by this court was to show that the current establishments nonetheless maintain a predominant sexual focus, fairly support that position. And the evidence the city adduced was extensive. It was different from what was before this court, and the city amply met that burden.
Thank you.
Thank you very much.